Good afternoon and welcome to the Rules Committee. I'm your substitute chairman today. Mr. Sessions is having some travel difficulties, and so we're going to go ahead and get going. Today, this is not the way we scripted it, Mr. Polis. We have a different script. Today, the committee will consider H.R. 1304, the Self-Insurance Protection Act, H.R. 1343, the Encouraging Employee Ownership Act of 2017, and H.R. 1219, the Supporting America's Innovators Act of 2017. Stop-loss insurance is not health insurance, and it has never been considered health insurance under federal law. H.R. 1304 would reaffirm this important and long-standing policy. By preserving self-insurance, workers and employers will continue to benefit from a health care plan model that has proven to lower costs and provide greater flexibility. The committee will also consider H.R. 1219, legislation that increases the limits on the number of individuals who can invest in certain venture capital funds before those funds must register with the SEC as investment companies under the Investment Company Act of 1940. Since the adoption of Dodd-Frank, it has become increasingly more difficult for small businesses to obtain crucial access to capital, especially at early stages of growth. Young entrepreneurs need more options, not fewer, to expand their businesses and create jobs. For that reason, I'm pleased to consider the legislation before us today. And finally, the last bill under consideration is H.R. 1343, which amends the Securities and Exchange Commission's Rule 701 to increase the threshold amount for requiring insurers to provide certain disclosures relating to compensatory benefit plans from $5 million to $10 million, and indexes the amount for inflation every 5 years. This legislation directly benefits small companies that are at the forefront of technological innovation and job creation, who often face significant obstacles in obtaining funding in the capital markets. I look forward to its consideration. I'd like to yield to my friend, Mr. McGovern, for any opening statement he might have.
Well, thank you, Mr. Chairman, and I want to thank our witnesses for being here today, and I appreciate you taking the time to come to the Rules Committee. But, you know, as I said at our last meeting, I very much regret the priorities that the Republican majority has set for this Congress. In fact, I think one of the bills that we're considering here in the Rules Committee passed on a suspension vote by an overwhelming margin last year. Maybe something's happened to make it more controversial, that it needs to get a special rule, but I think it's clear that what we're doing here is filler legislation, which I think is a shame given all that we need to accomplish. Now, Representative Mario Diaz-Balart, who's a member of the Republican Conference, said it best last week when he said, and I quote, "It's pretty evident that we don't have the votes among Republicans to, in essence, do anything that's real," end quote. And he remarked further that given the divisions within the Republican Conference, and he says, quote, "I'm not quite sure how we can move any of these big issues," end quote. So maybe that's why we're here doing this filler legislation instead of moving an infrastructure bill forward to put people back to work, or, you know, or his radical idea of finishing the FY17 appropriations process, which should have been finalized last year. I want to remind my Republican colleagues that our government runs out of funding on April 28th. That's 7 legislative days from now. And maybe some of you think that this legislation before us is vitally important, and that if we don't pass it, that Western civilization as we know it will come to an end. But I don't think anybody can say with a straight face that this is more important than keeping our entire federal government open. And for the life of me, I don't understand why we always have to get right up to the edge of the cliff and create all this uncertainty before we keep this government running. So, as I said last week, and I'll say it again, it's like the roof is on fire, and we are saying, I'll get the hose in a minute, but first let's wash the dishes. And that's what I kind of feel like we're doing here. But having said that, it's great to see my 2 colleagues, and I yield back my time, and I will be at the edge of my chair waiting to hear this testimony.
I thank my friend from Massachusetts. I, too, am ready to get on with the testimony. I want to thank Chairman Hensterling and Congressman Kildee for being with us today. Any written statements you have, we'd be happy to submit for the record, and we welcome your comments. Mr. Chairman.
Well, thank you, Acting Chairman Woodall and members of the committee. It is clear that since both Mr. Sessions and I live in Dallas, Texas, we clearly were on different flights since I am here and he is not. Nonetheless, I want to thank you for the opportunity to testify on H.R. 1219, the Supporting America's Innovators Act of 2017, and H.R. 1343, the Encouraging Employee Ownership Act of 2017. I want to start by thanking the Republican and Democratic sponsors of these bills. H.R. 1219 is sponsored by Mr. McHenry of North Carolina, the vice chair of our full committee, and Ms. Velasquez of New York. And H.R. 1343 is sponsored by Mr. Holtgren of Illinois, Mr. Delaney of Maryland, Mr. Higgins of New York, Mr. MacArthur of New Jersey, Ms. Sinema of Arizona, and Mr. Stivers of Ohio, members of both sides of the aisle. And with the exception of Mr. Higgins, every one of these members serves with me on the Financial Services Committee. So, Mr. Chairman, our committee has heard from countless witnesses that community banks and credit unions, the primary source of small business loans, are drowning in a sea of complicated regulations. Again, we are losing a community financial institution a day, and as we do, we lose credit opportunity for small businesses and startups. Ms. Karen Mills, who served as President Obama's director of the Small Business Administration, said, quote, "There is bipartisan agreement that small banks have been laden with excessive cost and confusion from overlapping regulations, which are getting in the way of their ability to make small business loans." This could not be more true, Mr. Chairman. The same occurs with the maze of securities regulations that were written with the largest public companies in mind, but instead burden small companies and hurt their ability to access investor capital. We must level the playing field while maintaining fair and efficient markets, protecting investors, and allowing small companies the chance to succeed. Regrettably, we are looking at the lowest level of entrepreneurship in almost a generation. That must change. We can make progress. We can make progress today in advancing the goals by advancing both of these bipartisan bills. H.R. 1219, sponsored by Mr. McHenry and Ms. Velasquez, was approved last month by our full committee, 54-2. A similar bill passed in the House last year, 388-9. H.R. 1343 passed the committee last month with support from more than half of the committee's Democrats on a vote of 48-11. H.R. 1219 increases the limit on the number of individuals from 100 to 250 who can invest in certain venture capital funds. Before those funds must register with the SEC as, quote, investment companies. This would permit angel funds to better help accredited investors invest in startups. As a result, investors will benefit from greater investment opportunities, and entrepreneurs will have greater access to capital. H.R. 1343 modernizes an SEC rule last updated in 1999 to allow the employees of privately held businesses to take advantage of the employee shareholder provisions of the Bipartisan Jobs Act. Doing so will encourage companies to offer greater incentives to attract and retain employees. Mr. Chairman and members of the committee, nothing in these bills eliminates investor protections, nor do they in any way lessen the SEC's authority to prosecute fraud or securities violations. What these bills do, however, is provide necessary regulatory relief that can hopefully kick-start stronger economic growth and help level the playing field for small businesses, and I appreciate your consideration of these bills today, and I look forward to answering your questions.
I thank the chairman. Gentleman from Michigan.
Thank you, Mr. Chairman, and members of the committee for allowing me to speak today on H.R. 1219 and H.R. 1343. H.R. 1219, the Supporting America's Innovators Act of 2017, is a product of successful bipartisan negotiation that achieves the appropriate balance between the need for capital formation, encouraging capital formation, and the important principle of investor protection. Specifically, the bill would provide a narrow exemption from the definition of an investment company for qualifying venture capital funds with no more than 250 investors and only $10 million in capital contributions and commitments. These funds must invest 80% of their capital in small company stock. The exemption is reasonably tailored to venture capital funds that are private in nature with only 250 investors that meet the income or net worth thresholds to be considered financially sophisticated under the law. The $10 million cap on investor capital limits the exemption to funds that are small enough that these investors are capable and able of monitoring and managing their investments. The investor and capital limits in H.R. 1219 also ensure that we aren't creating a loophole for genuine public investment companies like mutual funds to avoid regulation, nor are we providing relief to other private funds like hedge funds that have very little restrictions and investor protections. This bill is supported by Angel Capital Association because it will allow more investors to invest in venture funds which promote American entrepreneurship, businesses, and jobs. There are many issues that Democrats and Republicans disagree on in this Congress, but we can agree that encouraging just a little more opportunity to invest in our nation's future is important, and so I support this bill and urge my colleagues to do the same. Turning to H.R. 1343, the Encouraging Employee Ownership Act of 2017. This bill would eliminate some important disclosures that private companies must provide their employees in the event that they're compensating those employees with stock. Currently, private companies can and do provide more than $5 million worth of stock compensation over a 12-month period to their employees. But if they do so, those companies must make relatively simple disclosures to those employees, including 2 years of financial statements, which don't even need to be audited, and information about risks associated with investment in the securities. Employees deserve no less protection than other investors and may be more susceptible to suggestion and maybe at sometimes a disadvantage compared to other minority shareholders who may receive more information pursuant to other securities law exemptions. And I do understand that some of the supporters of H.R. 1343 believe that such an exemption is needed because disclosure by companies of this sort of information to employees runs the risk that confidential information could be shared with competitors. However, employees with access to such information could be subject to non-disclosure agreements, as they typically are today. Indeed, non-disclosure agreements are a simple solution that protect the company but do not deny the employees the right to understand the worth of or the risks associated with their compensation, as this bill would. Similarly, investor advocates have pointed out that it would not be to an employee's interest to disclose information to competitors because it would obviously negatively affect the value of their company's stock and reduce their compensation. This bill ultimately is about transparency. We should ensure that employees have information on stock that serves as their compensation. And though I oppose this bill, I do urge members to allow a full debate on the House floor and make all germane amendments in order. With that, Mr. Chairman, I yield back.
I thank the gentleman from Michigan. I recognize the point that my friend from Massachusetts was making, but candidly, I am glad we occasionally get a non-knockdown, drag-out bill up here. I think folks believe what they see on TV, and when you take a bill that, as Mr. Gildy said, was the product of very sincere bipartisan negotiation to solve a shared concern, and you pass it in 20 minutes on the House floor, I don't think folks get a chance to celebrate those successes. I'm glad while there have been amendments submitted to improve on that work product, I'm glad that we're going to have a chance to talk about that, and I appreciate you all bringing it today. The gentleman from Alabama, Mr. Byrne, do you seek time? I don't seek any time. All right. Gentleman from Florida? Gentleman from Colorado? There. Well, with that, gentlemen, thank you very much for giving us that ray of sunshine in an otherwise not yet rainy day. Does any other member seek to be recognized on H.R. 1219 or H.R. 1343? Seeing none, this closes the hearing portion on those two bills. The chair would now welcome Dr. Rowe from Tennessee to the table, and Mr. Scott from Virginia for testimony on H.R. 1304, the Self-Insurance Protection Act. Anything you have in writing, we'll be happy to submit for the record, and we would welcome comments from you both. Dr. Rowe.
Thank you, Mr. Chairman and Ranking Member. Members of the House Rules Committee, thanks for the opportunity to speak today in support of the Self-Insurance Protection Act. We all want to ensure that workers have access to high-quality, affordable health care coverage. That's exactly what this legislation is all about. Self-insured plans offer high-quality health care coverage at a reasonable cost for workers. And I might add, Mr. Chairman, that 60% of the private insurance market in this country are self-insured plans. Employers pay their employees' health care costs directly, and if the costs are lower than expected, those savings can be reserved for later years to help cover their workers' future health care costs. Through self-insurance, employers have more flexibility to customize their health care plans to fit the unique needs of their employees. These plans are also free from many of the restrictive requirements associated with traditional health care plans, requirements that limit choices and force employees to purchase specific benefits they may not want or need. 2016, more than 60% of employers offered health care coverage were self-insured. However, employers also take greater financial risk when providing this popular option to workers. To help mitigate that risk, many employers opt to purchase stop-loss insurance. Stop-loss insurance is not health insurance, nor has it ever been considered health insurance under federal law. What it does instead is provide employers choosing to provide self-insurance with a financial backstop protecting the benefits of workers and their families. Unfortunately, the former administration threatened to regulate stop-loss as traditional health insurance, a move that would have put workers and their families at risk of losing access to self-insured policies. That's why Congress must act to ensure no future administration will be able to restrict the self-insurance option. The Self-Insurance Protection Act does just that. This legislation reaffirms long-standing policies, prevents future bureaucratic overreach, and clarifies once and for all that stop-loss insurance is not health insurance. By supporting H.R. 1304, we will promote more choices and protect access to affordable health care coverage options for working families.
Thank the gentleman from Tennessee. Gentleman from Virginia.
Thank you, Mr. Chairman, and ranking members and members of the committee. I have a statement that I'd just like to introduce for the record and just make a couple of comments. It's a little unclear as to what we're doing here. This prevents federal regulation. There's no federal regulation now, and I'm not sure there's much prospect in any federal regulation. There's serious concern, if it's not regulated on the federal basis, that this bill may be interpreted as prohibiting state regulation, but we made it clear during the hearing, and it's in the report language, that this is not designed to prohibit states from regulating. When the gentleman from Tennessee says it's not health insurance, that's technically true, because it's if you're self-insured and you expect to be paying a certain amount, all of a sudden a couple of people get sick, you need protection against that financial loss, and that's appropriate. But if the trigger price is low enough, it operates just like health insurance. You have a $5,000 stop loss, anything over $5,000. Well, I mean, who gets to decide whether or not you get a liver transplant? Well, that's the stop loss insurance, which really should be, under this theory, a financial, and somebody else is making the health decisions. No, they're going to be making the health decisions. It will operate just like health insurance. But since it's not now regulated on the federal basis, and this bill, based on the discussion and the report language, doesn't stop states from regulating, we don't support it, but there's not much to oppose.
Yeah, I thank the gentleman for his testimony. One of the reasons I love being on the Rules Committee is that really smart people come up here and share with me to make me smarter. My understanding of stop-loss insurance is that it did not put itself in the place of the original insurer, but simply became a financial transaction as the rest of the insurance plan continued to operate as the insurance plan always operated. That stop-loss policy would indemnify the self-insured plan so that it was not a health care conversation. It was simply a dollars and cents conversation that happened.
You're absolutely right, and that's how it ought to operate, except if the threshold is low enough, the decisions of what health care you get, who's making it? If the employer says, well, I think you need a liver transplant, and the stop-loss insurance company says, oh, no, we're not paying for that, then they're acting like an insurance company.
If that were true, they absolutely would be acting like an insurance company, though my understanding of stop-loss policies is that's not the way they operate. Dr. Rowe, what's your experience?
Let me put this in English. Let me translate all this. I served 6 years on the city council in Johnson City, Tennessee, and was mayor. We had about 1,000 employees and their families, more than that, when you had their families for the city employees, and then we had the school teachers and their families. So we had 2 separate plans. The beauty of these self-insured plans, and the reason people are going to them, is allows you incredible flexibility. We put in the few short years, we put in diabetes management, smoking cessation, obesity, hypertension management. We were able in 6 years to basically, because we managed our own cost, to level that. Everybody at this dais up here buys insurance to protect their home, and you decide, hey, I can stand a $2,000 deductible or a $3,000 or a $1,000 car insurance, and then we purchase it. We purchased 5 insurance stop-loss plans every year if it went above $250,000 to protect our taxpayers. They didn't decide what health care was provided. We had a third-party administrator that administered the system. So the stop-loss people don't decide anything. They're certainly, we're motivated, we put it high enough, and his point is if it gets low enough, then it acts like health insurance. They still have that risk, and that decision is still made by the third-party administrator and the people that provide the insurance, what benefits we provided for the city employees. That's how it actually works.
And to Mr. Scott's point about who's pressing for regulatory action in this area, can you share with me the concerns that have led to the introduction?
Yeah, I was, the last 6 years, I've been chairman of the Health, Employment, Labor, and Pension Subcommittee, and the previous administration began to sniff around self-insurance, and basically this particular part of the insurance market is working really well. If you look around, I would encourage more people to look at it because it seems to be innovative, allows people to put wellness programs in and other things, disease management like we did that really help lower costs. So what we don't want any Republican or Democrat future administration to be sniffing around this. It's a part that's working. And the old adage, if it ain't broke, don't fix it.
I have grown weary of the pendulum being yanked back from the left to the right, to the left to the right. I applaud you for getting involved in this space before
Just leave it alone.
That's exactly right. Gentleman from Oklahoma.
It's always good to see my friends, but I have no questions on this issue.
Your friends thank you for no questions.
Actually, my friends up here thank me as well.
Gentleman from Massachusetts has no questions. Gentleman from Georgia. Gentleman from Florida. Gentleman from Alabama. Gentleman from Colorado. All right.
Thank you. Well, if the gentleman from Tennessee will certify that the stop-loss insurance people cannot make health decisions, that would be helpful.
They certainly didn't, excuse me, if you, Jim will yield, they certainly did not in the plan. I'm intimate.
I'll guarantee you, when you start talking about that liver transplant, they're going to be right at the table.
Actually, they're not.
Okay, well.
They were not where we were.
But I'd agree with you. They always work. They always work. Because if you can get a self-insured, healthy group at the lower cost, it will work. As soon as people start getting sick, they're going to abandon the self-insurance, jump into the regular insurance pool, and get insurance at the average rate. And so this same thing, I was up here on the association plans. Anytime, we're talking arithmetic. You are not reducing the medical expenses. We're just trying to figure out how to insure it. If you can get a little healthy group to come out here and self-insure or get an association and get a lower price, that's good for them. Arithmetic. Everybody else's costs just went up. And that's the problem with these little schemes where you try to violate arithmetic and don't lower the cost generally and just figure out how to insure it. Get your little healthy group out here. That healthy group, as long as they're healthy, can save some money. Everybody else's average cost just went up.
But that's exactly why, Mr. Chairman, you buy stop-loss insurance, to protect yourself from that outlier out there who might get really ill. That's why we did it. We bought 5 policies a year. We had about 2,000 employees, 1,800, plus their families. And we weren't going to abandon those people. We'd had self-insurance, we'd had a self-insured plan at the city of Johnson City for years, and we're not about to abandon that. You see more people going to it because they have more control. You can go in, there's another company, I won't mention it, that had 700 employees in my area that brought a very innovative young healthcare expert in there. And basically, and this is a manufacturing plant with a lot of people who were obese, who smoked and so forth, that brought those population type healthcare in there and for 7 years, even when you saw the rates going up for everybody else, they were flatlined. That's the thing we should be looking at, to try to bring more of this kind of innovation into the market, not less.
Gentleman from Colorado yields back. I thank the chairman, I thank the gentleman from Virginia for being with us.
Thank you, Mr. Chairman.
Does any other member wish to be heard on H.R. 1304? Well, this concludes the hearing portion. The chair will now entertain a motion from the gentleman from Oklahoma.
Mr. Chairman, I move the committee grant H.R. 1343, the Encouraging Employee Ownership Act of 2017, a structured rule. The rule provides 1 hour of debate equally divided and controlled by the chair and ranking minority member of the Committee on Financial Services. The rule waives all points of order against consideration of the bill. The rule provides that an amendment in the nature of a substitute consisting of the text of Rules Committee Print 115-11 shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule makes in order only the further amendment printed in the Rules Committee report, if offered by the member designated in the report, which shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, shall not be subject to amendment, and shall not be subject to demand for division of the question. The rule waives all points of order against the amendment printed in the report. Finally, the rule provides one motion to recommit with or without instructions.
You have heard the motion from the gentleman from Oklahoma. Is there any discussion or amendment? Hearing none, the question is on the motion. The gentleman from Oklahoma, all those in favor say aye. Aye. All those opposed say no. Opinion of the chair, the ayes have it. The motion is agreed to. Chair will now entertain another motion from the gentleman from Oklahoma.
Mr. Chairman, I move the committee grant H.R. 1343. Nope. Sorry. Mr. Chairman, I move the committee grant H.R. 1304, the Self-Insurance Protection Act, the closed rule. The rule provides 1 hour of debate equally divided and controlled by the chair and ranking minority member of the Committee on Education and Workforce. The rule waives all points of order against consideration of the bill. The rule provides that the amendment in the nature of a substitute recommended by the Committee on Education and the Workforce, now printed in the bill, shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. Finally, the rule provides one motion to recommit with or without instructions.
Is there any amendment or discussion? The question is on the motion offered by the gentleman from Oklahoma. All those in favor say aye.
Aye.
All those opposed say no.
No.
Opinion of the chair, the ayes have it.
Mr. Chairman, I ask for a roll call on that one.
The clerk will call the roll.
Mr. Cole.
Aye.
Mr. Cole, aye. Mr. Sessions. Mr. Burgess. Mr. Burgess, aye. Mr. Collins. Mr. Collins, aye. Mr. Byrne. Mr. Byrne, aye. Mr. Newhouse. Mr. Buck. Mr. Buck, aye. Ms. Cheney. Ms. Slaughter. Mr. McGovern.
No.
Mr. McGovern, no. Mr. Hastings. No. Mr. Hastings, no. Mr. Polis. No. Mr. Polis, no. Mr. Chairman.
Aye.
Mr. Chairman, aye.
Clerk will report the total.
6 yeas, 3 nays.
The motion is adopted. The chair will now entertain another motion from the gentleman from Oklahoma.
Mr. Chairman, I move the committee grant H.R. 1219, the Supporting America's Innovators Act of 2017, a closed rule. The rule provides 1 hour of debate equally divided and controlled by the chair and ranking minority member of the Committee on Financial Services. The rule waives all points of order against consideration of the chair. The rule provides that the bill shall be considered as read. The rule waives all points of order against provisions in the bill. The rule provides one motion to recommit. Section 2 of the rule provides that on any legislative day during the period from April 7th, 2017 through April 24th, 2017. The journal of the proceedings of the previous day shall be considered as approved, and the chair may at any time declare the House adjourned to meet at a date and time to be announced by the chair in declaring the adjournment. Section 3 of the rule provides that the Speaker may appoint members to perform the duties of chair for the duration of the period addressed by Section 2. Section 4 of the rule provides that each day during the period addressed by Section 2 of the resolution shall not constitute calendar days for the purposes of Section 7 of the War Powers Resolution. Finally, Section 5 of the rule provides that each day during the period addressed by Section 2 of the resolution shall not constitute a legislative day for purposes of Clause 7 of Rule 13.
The committee has heard the motion. Is there any amendment or discussion? Questions on the motion offered by the gentleman from Oklahoma? All those in favor say aye.
Aye.
All those opposed say no.
No.
Being the chair, the ayes have it.
As for a roll call, Mr. Chairman.
Clerk will call the roll.
Mr. Cole?
Aye.
Mr. Cole? Aye. Mr. Sessions? Mr. Burgess? Mr. Burgess? Aye. Mr. Collins? Mr. Collins? Aye. Mr. Byrne? Mr. Byrne? Aye. Mr. Newhouse? Mr. Buck? Mr. Buck? Aye. Ms. Cheney? Ms. Slaughter? Mr. McGovern?
No.
Mr. McGovern? No. Mr. Hastings? Mr. Hastings? No. Mr. Polis? Mr. Polis? No. Mr. Chairman?
Aye.
Mr. Chairman? Aye.
Clerk will report the total.
6 yeas, 3 nays.
A motion is adopted. For Republicans, H.R. 1343 will be handled by Mr. Buck.
And for Democrats, by Mr. Polis.
And for H.R. 1304, it will be handled for Republicans by Mr. Byrne.
And for Democrats, Mr. Hastings.
And H.R. 1219 will be handled by Republicans from Mr. Buck, by Mr. Buck.
And for Democrats, me.
All right. Unless there's any other discussion, this concludes today's business.
We should have Woodall chair all the time. Get this job